What's going on, everybody? My name is Mark Real Jr., the Father's Rights Attorney, and you are listening to another episode of the Father's Rights Playbook. On this episode today, we are going to tackle the most common question we get here at Real Father's Rights. And that question is, will I get 50-50 custody? We'll break down what the law says and what we're seeing on a day in, day out basis in the state of California right now. Now, before we dive too deeply in, I do have to tell you something. Some exciting news. There's a lot of stuff on the internet about it, but we are now taking cases in Northern California. We have officially opened our San Jose office. So if you are in San Francisco, Oakland, or San Jose, or the surrounding counties, we can now help you. So give our office a call today if you're in those counties and you need the help of a dedicated father's rights attorney. So let's dive into the question about 50-50 custody. Now, I work on two fronts when it comes to 50-50 custody. Here at Real Father's Rights, we are dealing with how the laws are currently constructed, how they're currently written, and what's going on in courthouses today. Every single day, the attorneys here at Real Father's Rights appear in dozens of courtrooms across California, helping men and fathers navigate through custody proceedings. And we find the vast majority of fathers, they don't want to take full custody and take anything away from their co-parent, the mother, their ex, whoever that may be, but they want to ensure that they are a key part of their children's lives. On the other side, I do a lot of advocacy work, and I get asked the question, well, what are you doing to fix it? I just about 3 weeks ago was in Washington, D.C., meeting with Congress people and hosted a pretty large event at an exclusive club where we're able to talk to legislators about the problems, and we do this at the state level as well. Now, unfortunately in California, the advocacy work, we probably, honestly, just being very transparent with you, are probably years away from having a realistic shot for a 50-50 presumption bill, which creates a presumption of 50-50 custody upon divorce or separation in the state of California. We are years away from that. We are not going to have what Kentucky or West Virginia or Florida or Arkansas or Oklahoma or Mississippi has. But I can tell you what we're doing on the law firm side of things and what we're seeing. So commonly in an initial meeting with an attorney or with myself, someone will ask, what is the likelihood I am getting 50-50 custody? So let's break down what the law currently says and how it's being applied. So number one is California is a best interest of the child state. So essentially the standard is the judge is going to simply evaluate what is in the best interest of the child. What does that mean, though? In terms of evaluating the best interest of the child, they're going to look at stability. They're going to look at status quo. They're going to look at who can provide for the health and well-being of a child. So there's a number of factors they are going to look at. Now, the one cool thing is, over the last 5 years, we have seen more and more judges take the bench that, even without a presumption of 50-50 custody, push and really start in their mind with both parents need access. And that's actually part of the family code. The family code says that frequent and continuing contact with fit, willing, and able parents is what's in the best interest of the child. But as we know, family court cases get messy. If you go into your custody fight, if you go into court and there are no domestic violence allegations, both parents can provide a safe place for the kids to live, the parents live relatively close to each other, Both parents can ensure the kids get off to school in the morning and are taken care of when they get home. Those cases, we're increasingly seeing judges grant more equitable timeshares. So without any complicating factors, we're seeing more and more judges look for reasons to grant more equitable timeshares. Now, does that mean it's exactly 50-50 all the time? No. But we're seeing a lot more 40-60, 45-55, and 50-50 arrangements week on, week off, 2-2-3, different schedules like that create that more equitable timeshare, which all of the studies for the past 25, 30 years now point to more time with each parent, maximizing the time with each parent is what's truly best for the children. Now, where family court gets messy and where the laws in California are flawed are around domestic violence and then the handling of more complicated matters. So I'll start out with domestic violence. Now, I'll start off by saying that victims of domestic violence need to be protected, both men and women. And if you commit acts of domestic violence against your co-parent, it's probably not in the best interest of your children to then turn around and have a 50-50 arrangement. Because if a parent's committing domestic violence on their co-parent or has in the past, that does increase the likelihood that there could be some sort of incident or it's not in the children's best interest. Where California goes astray is over the last 6 to 7 years, the definition of domestic violence has expanded. We've added coercive control. You see a lot of news coming out of Arizona where they used to have the best custody laws in the United States. Prior to Kentucky passing 50-50 in 2018, Arizona probably had the best custody laws in the country. It isn't a presumption of 50-50, but it's very strong language. But we've seen the news lately that they've passed in their family code, coercive control is a form of domestic violence. Now, we've had that in the state of California for over 5 years now. So domestic violence is not just simply physical violence. It can be mental, it can be emotional, it can be financial abuse. And then we have this coercive control, which has continued to broaden. Now, this is problematic because California has what's called Family Code Section 3044. And the short version of what Family Code Section 3044 says is that if one parent has been found in family court to have perpetuated domestic violence against the other, it is presumed that they should not have legal or physical custody for a period of 5 years. So essentially, you're limited to visitation. And we have had appellate cases come down that really limit the amount of custody and the amount of decision-making power that a parent that has been found to have committed domestic violence can get. The appellate law, the case law that governs what these judges do, essentially says that if you're found to have committed domestic violence against your partner, that you should not have custody for more than about 30% of the time, which is slightly more than every other weekend. This is problematic because domestic violence restraining orders get weaponized. False allegations, the standard, preponderance of the evidence. It doesn't take any actual physical evidence. There is a very, very low standard for a family court judge to find that domestic violence has occurred. And one of the flawed pieces of thinking is you can be found to have perpetuated domestic violence without the presence of a request for a domestic violence restraining order. A judge can simply make that finding. And if there's a finding of domestic violence, the presumption is going to be that the parent who was abused, or the court found was abused, is going to get sole legal and physical custody until the parent who was found to perpetuated domestic violence has rebutted the presumption. And what does this mean? This means you must go into the court and prove, based on taking the courses, how the situation has changed, that this presumption shall no longer apply. Now, we're seeing more and more judges find the presumption to be overcome, but that's a long and expensive process. And as I mentioned, under the current statutes in California, the status quo holds a lot of weight. So we see a lot of cases, it's primarily mothers, but both mothers and fathers weaponizing the domestic violence process, creating a status quo of them having primary custody, and then it's a long road, a years-long road for the parent who is found to have committed domestic violence or even simply accused of domestic violence to get back a substantial timeshare. So that's the number one piece that we see that prevents 50-50 custody. And statistically, about 30 to 40% of our cases involving custody also involve allegations of domestic violence. So this is not something that's isolated. This is something that's used as a tool by parents wrongly to gain an edge when it comes to custody. The other issue is the status quo piece. We see a lot of cases where allegations of domestic violence, a lot of times you hear it called the silver bullet method. They make what I would refer to as very flimsy domestic violence allegations or child abuse allegations or substance abuse allegations, and the parent the allegations were made against ends up getting an unfavorable temporary custody order. And then they must work their way back from that. And even if you prove that the allegations weren't true, there's now a 6-month, 1 year, 2 year long status quo of the other parent having primary custody. And the judges will then revert back to best interest of the child in terms of determining what the custody arrangement will be going forward. So we see situations where, unfortunately, it may take a year or two for domestic violence allegations to be litigated out and proven false or proven true. Well, when they're proven false and we don't have a 3044 presumption, but mom's been the one with primary custody for a couple of years and the kids are in a certain school, they're used to a certain arrangement, the judges then, under the current laws, can justify keeping the status quo or further limiting the accused parent based on what has been occurring. So this is something where the weaponization of domestic violence, it's so common in California and really all across this country. And it's a really, really hard question to answer, hard question to deal with without the presumption of 50-50 custody. Now, I want to say this. There are some really, really good judges on the bench that if an allegation is proven to be false, that they will look at the totality of the situation and say, like, I can't reward one parent and ultimately harm the kids by limiting their contact with a parent who was proven to have not committed said domestic violence. The second part of this is something we see weakening in California and really nationwide. And when you're in a relationship with someone, you play roles. One parent may not be working, or one parent may have a job that allows them to care for the children during the day or do certain things, while the other parent's role is to more financially provide. And 5 years ago or so, you would see situations where, let's say mom didn't work when parents were married, but they separated. And a judge would automatically default to, well, mom was the one who took them to their doctor's appointment, or mom was the one that made sure they were off to school. Mom cooked all the meals, so we don't want to disrupt that. Now, there's a lot of studies, there's a lot of research that show that this isn't necessarily what's best for the kids, but this is something that's long held in family court. So getting back to the question of will I get 50-50 custody, it's a very complex question, and it really, really depends on your specific situation. And going into court, when we have a dad, we're going to want to look at all the factors. We're going to want to present all of the facts that show that maybe you weren't as involved in a certain area of their life, but it was because you were playing roles, and we want to really show that you are capable and you are willing and able to fill those roles now that one household is going into two. So with all that being said, I will say this. We're years away from a 50-50 presumption in California. Doesn't mean we're not working on it. Doesn't mean we're not trying. There's actually a bill filed this year. To be completely candid, it's going nowhere. But we are working towards that, and we have plans for steps in the future where we're not going to jump straight to a 50-50 bill, but we have strategic steps planned to eventually get us to a point where we can get a bill like that passed. But when it comes to today, we're seeing more and more equitable arrangements. We're seeing fewer and fewer every other weekend dads. So you have a better chance today of getting 50-50 custody than you ever have before. But that doesn't mean it's guaranteed. And you see a lot of judges now trying to get away from creating every other weekend parents, which every other weekend results in 20 to 30% custody. We're seeing a lot more judges try to maximize the time with each parent. And maybe in your specific situation, a 40-60, a 45-55 arrangement is what ultimately ends up working best based on what each parent can provide. But I will say this, that the likelihood of a 50-50 arrangement is increasing. More judges willing to go week on, week off, or these other schedules, 2-2-3, or every other Wednesday type of situations where it is 50-50 custody. So there's no guarantees. There are a lot of things that can get in the way of it, chiefly our domestic violence laws currently. But if you remove all of those, your likelihood of 50-50 custody is significantly higher than it was 20 or 30 years ago. So that's something that's really exciting. Also, I'll say this. One thing we've seen over the last few years is the trend of mom being the breadwinner. We're seeing more and more dads get 60, 70, 80% custody based on what status quo and what was going on. One of the funnier situations when it comes to custody and child support and all these factors is we're seeing more and more women be those breadwinners. Something like almost 70% of college degrees, a huge chunk of advanced degrees are going to women. Really completely different topic, but our education system in a lot of ways is failing men and boys. And one of the things that's changing because of that is there are more dads that are primary caretakers, or there are more moms that are working more demanding jobs that require a lesser custody schedule for them to maintain their profession. So you can never guarantee anybody 50-50 custody. And if in an initial call someone asks me what's the likelihood of me getting 50-50 custody, the first thing I tell them is there's no guarantees in family court. But if we're able to show the right things and do the right things and candidly avoid some of the bad judges that are on the bench, you do have a shot to have 50-50 custody. Whether you were the primary caregiver during the relationship, whether you worked and your co-parent was the primary caregiver, there is an increased likelihood of you having more custody today. So that's what I have on will I get 50-50 custody. Hope you guys found this informational, educational, maybe a little bit entertaining. And I'll leave you with this. Family court a lot of times can be a long road. And there are still situations where deserving parents, deserving dads get an initial temporary order that is unjust, unfair, just simply not right. And we see more and more dads staying the course. I've seen dads who have been involved in family court for 5, 7, 10, 12 years. And finally, after all of that time, they're able to get that substantial time with their kids. So if you're concerned about what's going to happen and your case is just starting, or you're contemplating divorce or separating from your co-parent, the likelihood's higher now than ever. But understand, the courts aren't perfect. There are still so many changes that need to be made. And if you're one of those that, unfortunately, you're going to be in family court for the long haul, it doesn't matter how long it takes. Keep trying to be there for the kids. Keep being there for your kids. And keep being a great father. So we'll see you guys again next time on another episode of the Father's Rights Playbook.